Okay, this is part 6 and the last segment in the coverage of the January 23rd, 2025 hearings, State versus Koberger. This is Ann Taylor doing the defense's rebuttal to the state's rebuttal to the defense's motion for a Franks hearing. So let's get started.
Before I get started on what I want to tell you, in response to what the state said and then my summary, I'm curious about the new police report that was talked about. I didn't see it in the submission given to Your Honor.
I've had such an avalanche, I can't think of what it is off my head. If it did, it certainly wouldn't be part of the analysis for the court in determining whether or not you've met your showing to have a Franks hearing.
Now that's interesting. That perked my ears right up. A new police report. Wonder if it was presented during the closed hearing? Or this was something new that was just turned over in discovery the last couple of days? You have to wonder what it pertains to. Hopefully we shall find out in due time.
Well, that's good because it occurred after my Franks briefing came. So I didn't get a chance to respond to that yet. All right, let's start with the grand jury subpoenas. And yeah, we wanted those in discovery. We didn't get those. We were told no a couple of different times. The issue with that is that at least one of the warrants was used, the returns from the grand jury subpoenas, it used the return from the grand jury subpoena to obtain information. And we don't have those, so we don't know the scope and parameters of that. So the magistrate relied on something that's not reviewable by us. And that's kind of gotten to be...
Amazon.
Sorry?
Is that Amazon?
It is Amazon, Your Honor. And the return on the search warrant says that they already produced them pursuant to something else. And the affidavit says, we saw these things, so now give them to us in a search warrant. That just seems to be problematic to me.
Of note, Amazon falls under the third-party doctrine anyways. So really a warrant or subpoena is not needed. That's just a decision that Amazon, would make on their own, whether to turn over information or not. But third-party doctrine, there's no expectation of privacy when you go on those websites or give your information to those websites. So your purchase history, etc., you have no expectation of privacy over. So I just wanted to point that out because there really isn't any hanky-panky if she didn't get those federal subpoenas anyways from Amazon, from the Amazon search.
It's kind of the same thing that's laying on pretty thick here. You can't have it. We're not going to tell you about it, but don't worry, we didn't do anything wrong. And that's a problem. That's a theme of this case, and that's really a problem. So I think we should have a Franks hearing to explore what that really is about, if for nothing.
What's the omission or the misstatement that as it relates to the Amazon warrant?
The omission is the FBI used the grand jury system and obtained this information outside of the warrant process, but for some reason, we need to come and get a warrant because nobody gets to... I have them in other cases, Judge. I don't know why they're withheld here. It makes me really suspicious.
Well, I guess from a Franks perspective, though, the question is there a material intentional misstatement or a reckless misstatement?
Correct, and that's what Ashley was also wondering. What is their Franks material in not having this grand jury subpoena for the Amazon information?
From Frank's perspective, was it material? Well, it was relied on to get the warrant, right?
It disclosed to the magistrate that this was the result of information given as a result of a federal grand jury.
It absolutely was.
What did they say that was not true, or what did they fail to disclose?
I think they failed to disclose the parameter around that grand jury subpoena.
How is that? Well, I, I, I understand. I promised I wouldn't slow you down, so I'm gonna let you just go ahead.
Okay.
Darn it, Hitler. I wanted to hear how she would have answered that. Oh well.
I'll go backwards. The 7 minutes that's not disclosed, that's intentional, that's not given to the magistrate to make the decision. There are a lot of these things that are intentional withholdings and a lot of things that are deliberate. You heard a lot earlier today about the hours of meetings that took place and the decisions to keep certain things secret. So I think we've satisfied the prong of deliberate and intentional withholding from the magistrate or deliberate false statements to the magistrate on all of those areas.
Okay, so what I would like to know by her answer there, is she just assuming because they had all these meetings that they got together and decided to purposely withhold things or purposely put in things that weren't true? Or does she actually have proof? Does she actually have notes from those meetings? Like maybe somebody recorded those meetings or email chains from those meetings. I would love to know how she's making that assumption that just because they met so often that they were using those meetings to purposely deceive the magistrate in the affidavits.
I want to talk only about a couple of other things. The credibility of the witness that they talked to, the one that they cited information from, that was relied on. That appears in these affidavits, and it's relied on after Mr. Koberger's identified to say, well, he has bushy eyebrows, so this person has to be right. It's relied on when the police officers put into the affidavit the footprint that I didn't talk about on my first one. We gave the court the photographs of it. I'm happy to give the court these. That's a misleading statement to the court or to the magistrate that was asked for probable cause. This footprint is at the very edge of the door. It's a single footprint and it's not repeated throughout the house. So to act like that bolsters this witness is really important, especially in context of the misstatements of the witness. I want to go through these. I won't read them in their entirety to the court, but Your Honor asked the prosecutor what they were. And I counted up, and at the very first interview, remember the issue was whether or not one of the victims ran downstairs. And she didn't say it once. She said it 4 times in a row in the very first interview. And that just didn't happen. It just couldn't have happened. And that.
Okay, a couple questions I have on this. Earlier in one of my last videos, I said, A, how would that be exculpatory to Koberger? Whether somebody did run up and down the stairs or not. How would that rule him out as the suspect? I don't see how that would make a difference to who the suspect was. It would just make a difference to how things went down, but not who did it. But now my second question is, she's saying it's just not possible. Well, how does she know it's not possible? What information does she have that Dylan really did not see one of the victims run up and down the stairs? Like, yes, we know Dylan said that she didn't know she was dreaming or not, but what if she really did see one of them run up and down the stairs? What is Anne basing her statement on that it just isn't possible? Is it from the forensics experts? Is it from, how quickly the autopsy showed that they passed away, for example, after being stabbed? What? I would love to know this. Of course, I guess we won't know any of this till trial.
That was not told. In fact, that statement was brushed over and withheld from the magistrate. About the memory issues in the second interview the same day, there are 2 references to not remembering. A couple of days later, there's the third interview, and there's references to not remembering, being drunk, a statement, I don't know any of it. Like half this stuff, I don't know if it's a dream or if it's real. That's at page 399. At page 406, I don't know if this was real or in my mind was just like playing with me. But from what I think I heard, someone was crying in the bathroom. These are definite statements that were not given to the magistrate and in fact were brushed over. And credibility is really, really important when that person is relied on in the investigation.
But again, how is that exculpatory? Especially when you have a whole bunch of other things that they included. It just, I failed to see how, whether she wasn't sure if it was a dream or not, is exculpatory to who committed the crime. Okay, so throw out bushy eyebrows. She still saw somebody dressed all in black, a male, a white male that was taller than her. So how is that exculpatory? That's what I would love answered.
So let's talk about the vehicle. The court asked some questions about what the magistrate could see in the PC affidavit. The way it's laid out would cause one to think that the vehicle's identified on the camera near the house, and that's not so. It's not identifiable. The state's expert said it's not identifiable from that particular video. It's piecing together the other videos that they come up with something.
What's the evidence that law enforcement relied on the Ridge Road footage to identify the vehicle?
What did they rely on?
What's the evidence that they relied on Ridge Road, which you say doesn't show anything? What's the evidence they relied on that to ID the vehicle?
They relied on the Ridge Road camera, and you can see that in the emails from Imel and the other law enforcement officers when they say they have Paradise Creek Road, and then they say we finally got a good one, and it produced to us is the 1125 Ridge Road footage and photograph, and that's the only one that you can make a positive ID on the car.
Where is that in the record?
The 1125 Ridge Road. Well, it's in our discovery.
Or is it in the motion?
I believe we put a picture of that in our motion. I can look at it's in my original memorandum. I think there's a picture of that. Let me grab that page for you.
So, because in one of the emails, somebody said we finally got a good one, and is saying that she knows for sure that's the only video that they had a positive ID on. It sounds to me like she's making assumptions, or it's her own opinion that the other videos weren't good enough to be relied upon. And I think that goes back to what Ashley was saying, was that opinions are not Frank's material. You hash those out in court between the experts. So, yeah, that's going to be interesting, again, to see the videos.
You know, I believe it's on page 17 of the amended memorandum.
That's just the photograph?
Yes.
But not the information that ties that to the Ridge Road camera?
Your Honor, it's tied by our argument based on our review of the discovery. I don't have an affidavit from any police officer saying it was that. I probably don't have an email other than the ones from Immel and that transaction that we did provide for the court, that was the video that the identification was made on. That, I'd love to know more about that as well, Your Honor.
Oh, but that's not the standard.
I understand that. I understand that. I would refer the court to our exhibit with Agent Immel's communication. I believe that is going to be at D9, and then the pictures contained in the Frank's motion. Let me talk a little bit more about IGG, even though we've done that all day long today. I would remind the court that IGG doesn't identify a person. It suggests a family group, and an investigation can happen from there, but nothing happened until the IGG happened behind the scenes and in a closet.
Sure, let's just keep beating a dead horse with this IGG issue. I don't think it's going to go anywhere with Hippler.
That brings me to talk about the intentionalness of this in an overview. And the court should look at the entire picture of what's happened. It's a long investigation. It's a complicated investigation, but you have law enforcement repeatedly meeting and you have FBI agents sprinkled in. And there are a lot of things that you've heard about today that are withheld, that are super secret, that nobody's going to talk about. And there's a lot of meetings that are happening, particularly around the IGG. That's a definite, we're not going to put that in there.
Well, yeah, again, because the IGG is not discoverable and it was just a tip, so why would they put it in the probable cause affidavit? But also be careful what you wish for, because if they had put it in the probable cause affidavit, it would have been inculpatory. I don't get how she's not understanding that would be inculpatory to her client, not exculpatory.
But there's also the communication about the AT&T records, about what do those phone records mean? What does it mean when there's calls being handed off or phone tower reporting being handed off to track a vehicle? What does that mean? There's communication about that. There's review of the videos together. And what these things mean is that a partial picture was decided upon, a picture that left out a lot of detail, a picture that gave false statements to the magistrate to get probable cause to get that first AT&T warrant.
So here's the thing. Probable cause affidavits for warrants and arrest warrants are always a snapshot of what you have at the time. They are partial in nature. They're never the complete story because you're still building on your investigation as you go, even after the person's arrested. They are literally a snapshot in time when that warrant was written, not things that you discovered days after. So when she says it's a partial picture, yeah, bingo, it is. And I'm not seeing how that's Frank's material.
That was, the officers went back and forth talking about what kind of statements to use. Statements were changed to be included in that, and definite decisions were made at that time. The decision was made to leave the witnesses' statements in as they were, even though there had been interview after interview after interview, and they knew those were incorrect. The decision was made to build a false investigation and leave out the super secret IGG part. And that decision was made based on the behavior of the agents and based on not wanting anybody to review what they did so that we could check their work and see if they did anything right. That just continued with decisions to leave things out in this case. Probable cause doesn't get determined by one little thing without context, especially when there's context of omitted information. That's why we have the opportunity for a Franks hearing, to ask for a Franks hearing and to offer information for your honor to rely on. It is imperative that there be integrity in the warrant process. There's a lot of power in going to a magistrate and having no attorney there, nobody to cross-examine, nobody to question. There's a lot of power in that to obtain a warrant. And there's a lot of danger when there's that much power too. To leave just a little out here, to add a little more here, and go get a warrant, and then build everything that comes from that. And that's what happened here. Your Honor, we ask for a Franks hearing to more fully explore these. The court can see this is a massive amount of information. The court has 1,000 pages. These aren't just pages that we made up. There's a lot going on here, and we need to have a hearing to fully explore this. Thank you.
Okay, sorry about those glitches there at the end. That was from the Law and Crime Network, but 1,000 pages. I would love to know what's in those 1,000 pages, because just what she presented Doesn't seem like it would be 1,000 pages of Frank's material, so quite interesting. So we shall see. As of right now, when I've made these videos, nothing is showing on the case summary about Hippler having made a decision yet on whether there'll be a Frank's hearing. Nothing on those motions to suppress yet. So this concludes my last video on the January 23rd hearings. And then hopefully later this week, I will get started on breaking down the January 24th hearings. So, again, thank you so much for watching. There's lots of content creators. I understand you couldn't go to anyone, so thank you for watching my content. And if you have any questions, leave them in the comments. Thank you.